2020, I believe, the fall. What struck me during the course of that trial is how somebody who's so intelligent can do something so stupid.
Your Honor, our family trusts the court in this regard. Whatever decision the court makes will be okay.
Welcome back. In 2020, Max Atiyeh was sentenced to prison after a high school football game dispute turned into a serious criminal case. It started at a Mentor High School homecoming game with something as small as a beach ball. A disagreement involving his younger sister grew bigger after Max was pulled into the situation. Later that night, the conflict moved to another student's family home, where the student's father opened the door and was badly injured. Max was not accused of throwing the punch himself, but prosecutors said he drove there, brought someone with him, and helped set the confrontation in motion. A jury convicted him under complicity, and the judge sentenced him to 8 to 12 years in prison. Now, after nearly 6 years behind bars, Max is back before the same judge. This time, the question is no longer what happened that night. It is what should happen to him now.
We are present this morning in the matter of State of Ohio versus Majid Atiyeh. This is case number 19 CR 1073. Present open court this morning is the defendant with his attorney. We are present on a motion for judicial release. This is actually the second motion for judicial release filed in this case and a request for a hearing. The state did receive the motion and did file a response not objecting to this. The victim's family is also here and was informed of this prior to the state's response, and the state is prepared to proceed today.
All right, Mr. Perez.
Thank you, Your Honor. Your Honor, we submitted a motion on this case that is pretty extensive on behalf of Mr. Atiyeh. His name is Majid, but he goes by Max to everybody who knows him. He's been incarcerated for about 5 years, 8 months. He made a bad decision a long time ago, 8 years, about 6 years ago. He regrets that decision. He's done tried to apologize, and I think he's written a letter to the family, the Anukans that have been hurt by this whole situation, were the victims here. He's very remorseful. He's done everything he can while he's been incarcerated to prove to the court and the community that he's a worthwhile candidate to be a full-time citizen. He obtained a college degree while he was incarcerated. The court might recall before this event occurred, he was attending Cleveland State and would have had an engineering degree in a couple of quarters had he remained out. He has done more incarcerated than any client I've ever had. I've submitted numerous exhibits of all his accomplishments. He's attended basically every program that is available. He's had glowing remarks from prison personnel, the wardens, from the guards, the teachers he's had while he was in there. He has tutored other inmates in addition to everything else he's done. I think the court can be assured that if he is released and put on probation, that he will comply with any of the rules of probation, that he will not harm anybody in the community. He's not a risk to anybody. So there's so much I could say about him. I mean, I've submitted an extensive motion with all his accomplishments, all his certifications, all the support he has in the community. His family and other community members are here in support of him. I'm very impressed with him, with what he's done since this incident. I'm impressed with how remorseful he is, how well he understands what he did was wrong. And he is genuinely remorseful. He's not just saying that. So I would ask the court to consider everything we've already filed rather than rehashing it all in front of the court at this time. I've attached, numerous exhibits to the motion that outline everything he's done, support from community members of the community, and we would ask the court to grant him judicial release. I don't think he needs any transitional control because of the fact he's taken every course that would be offered at NeoCap or anywhere else. He's tutored other individuals in those same areas while incarcerated. He's low risk before he went in. He's a low risk at this point based on the prison guidelines. So I would ask the court to consider granting him shot probation without transitional control. He has a job waiting for him. His family, he'll be living with his family here in Menor. In Willoughby Hills, right?
It's Menor.
In Menor. He's living with his family in Menor, and I have every confidence that he'll be a great candidate for a probation judge.
Thank you. Mr. Attia, what do you want to tell me in support of this motion for judicial release?
Well, honestly, Your Honor, I applied myself, man. I try to better myself each and every day. While I was in prison, I did everything I can. I took advantage of all the resources that were available to me. I completed all the programs that I could. I'm sorry for what I did that day. I'm not a bad person. I just made a bad mistake. And I apologize. I understand the seriousness of my offense. I understand the ripple effect behind it. I didn't just affect my family and the Finucane family. I affected the whole community. And I have a lot of love for this community, so I regret it. And I'm honestly embarrassed by what I did. And I apologize to you guys. I hope you guys can forgive me. If not today, maybe sometime down the line. You guys didn't deserve that.
Your Honor, the victim's family is here, and I think I want to give them an opportunity just to make a brief statement.
All right, just state your name for me, please.
Joe Finucane. Your Honor, our family trusts the court in this regard. Whatever decision the court makes, we'll be okay with.
All right, thank you. Go ahead.
Your Honor, in reviewing this motion for judicial release, I had extensive discussions with the victim's family, the police, and our response in this case was not taken lightly, given everything about this case. But ultimately, I think what Mr. Finucane just stated is exactly how the court feels, or exactly how the state feels as well, which is if this court determines that judicial release is appropriate, the state doesn't want to stand in the way of that and trust the decision of the court. We noted that in our response, not objecting, and so we defer to the court, obviously, on this.
All right, thank you. Okay, I've gone back and reviewed the pre-sentence report and the victim impact statement. The docket in this case, and I remember the trial well, it was 2020, I believe, the fall of 2020. And what struck me during the course of that trial is how somebody who's so intelligent can do something so stupid. You managed to manipulate this other fellow, I forget his name, it escapes me at the moment, into doing what you did. Mr. Downing had mentioned when we were in chambers about, in reviewing Mr. Perez's motion with the attachments, what was accomplished while you were away. And quite a bit was accomplished while you were away. And by comparison, most individuals who go to prison accomplish drug usage while they're away, and that's about all they do. So that I've taken that into great consideration. I've reviewed in this motion. I know you filed a motion previously last fall that I denied, but I went back and reviewed all the information that was the exhibits in that motion and reviewed this motion as well. So, how old are you right now, Max?
I'm 27 years old.
Okay. And when this all happened, I think you were 20 or 21, on your way to a engineering degree, right?
Correct.
All right. What else? I let you out. What are you going to do?
Go work for my family's business. I'm going to take care of my family, start my own family. I'm thinking about going back for my chemical engineering degree too.
How much did you have left in order to get that?
I have 1 year left. Franklin University also offered me to take a master's program online, so I was thinking about that as well for the business.
Well, in consideration of the entire record, I'm going to grant your motion for judicial release. I'm going to place you on community control for 5 years. You're to not utilize drugs in any manner, including marijuana, which in Ohio may be legal, but you're not to use it. You're to have no contact with the victims, at least at this point. I'm not sure if your license is still valid or not, but you're to get a valid license. You're to maintain full employment or full-time schooling, or a combination that equates to of both that equates to full-time. And you're going to complete 200 hours of community service. Ms. Warren, any other terms you think are applicable? Okay. You understand the terms?
Yes, sir.
Okay, if you don't comply with the terms, the state will file a motion to terminate your community control, and if it finds you violated, there's another 2.5 years or thereabouts left, up to another 4 after that. So when I sentenced you back in 2020, 5.5 years ago, and I looked at your record, you had no record. Okay? And I gave you the definite minimum. I gave you of 8 up to an indefinite 12 was the most you can get as an indefinite minimum, and I did that for a reason. Okay. So here's your opportunity to avoid any more of that stuff.
Thank you.
Anything else, Mr. Downing?
Just ask for an additional condition of no contact with the co-defendant, Dewan Lewis.
No contact with Lewis either. Mr. Perez, anything further?
No, Your Honor.
All right, we're adjourned.
What began as a high school misunderstanding turned into years of consequences. A beach ball, a confrontation, and one decision led to violence, prison, and years of accountability. The law did not look only at who threw the punch. It looked at who helped set the confrontation in motion. But this hearing was about what came after: remorse, proof of change, and the responsibility to live differently. Judicial release is not an eraser. It is a test. The judge gave Max a chance, but that chance now depends on every choice he makes next. If this case made you think, drop a comment below. Subscribe for more real courtroom breakdowns. More cases are coming up.